We started this evening on some sad notes, and we're ending this evening with hope. We have hope in Satana holding the DA's office in Durham, North Carolina, all the way across the country. And we have hope in our next and last speaker, Jeff Deskovic. So I'm briefly going to introduce him, but before I do that, tomorrow is Mr. Deskovic's birthday. Not only that, but it's a double celebration for him, because a few days ago he calls me up and he's all excited because he passed the bar exam. So in honor of Jeff, we have purchased a cake, which is in the back, and we're all going to sing Happy Birthday right now. And don't make me sing, but everybody else sing. Ready? 1, 2, 3. Happy birthday to you. 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 So please go to the back and help yourself to cake, as in a second I'm going to have Lisa introduce Jeff, but I want to say a couple words myself. So I first met Jeff in New York in March, and the funniest part of my trip to New York was the shock of going from relatively balmy California to freezing cold New York, where you have to bundle up before you go outside, because if you wait till you go outside, it's too late. And you can't walk around with your jacket open because it's so cold. You got to bundle up the jacket, which in California you never have to do. And so that definitely caught my attention. We had breakfast early in the morning, and I told him what I did, and he's like, "Well, I got to come out there and speak." I'm like, and he's like, "I'll pay for it." I'm like, "Okay, good." But he says, "It'll cost you something." And so the deal was we'd sing Happy Birthday and get him a cake. So it seemed fair to me. I've gotten to know Jeff, and it was really funny because a couple months ago I was reading this book on wrongful convictions by a professor. I think he may actually be at Duke, Professor Garrett. No, he's not at Duke, but anyway. He starts talking about Jeff, and I'm like, "Hey, I know that guy." But I've gotten, the thing is that I've gotten to know so many people, unfortunately, that have been wrongly convicted, and some of them are out, and unfortunately all too many of them are still in. And I'm always amazed how not bitter they are, because I think if I had lost 17 years or 41 years in the case of Marvin, I'd be bitter, and I don't know that I could survive that. And I wonder sometimes how some of the people can survive that. I read Anthony Ray Hinton's book where he's in a 5x7 cell in Alabama for 30 years, and for a good portion of that time, they wouldn't even let him have books. I mean, can you imagine? You're stuck in the cell all day, and they won't even let you get a book to read. It's a horrific system, and I'm amazed that Jeff has come out of this sane. And I'm also really respect his intellect and his measured approach to what he does, because he's taken what could be a tragedy that would destroy a lot of people, and he's get people that are stuck in prison, who don't belong in prison, out of prison. And so I have a great admiration, and he's been an inspiration in what we're trying to do here in Yolo County in some of our work looking at post-conviction cases as well. So I'm going to turn it over to Lisa Ray, who's going to introduce our keynote speaker, Jeff Deskovic.
I think he just stole my thunder there. I'll make this really short. Let me just say that I met Jeff online. And when I met him online, I thought, I got to interview this man. And so I did. But let me just do a quick introduction. So he was wrongfully convicted at 16, as you read, in New York, and was convicted for rape and murdering a high school classmate. He was in prison for 17 years as an innocent man from the age 17 to 32, and he was released in 2006 due to DNA. He's the founder of the Jeffrey Deskovic Foundation, based in New York, which works to free the innocent, and he earned a bachelor's and a master's while in prison. And yeah, wow. And then, as you heard, he earned a law degree from Elizabeth Hobb School of Law at Pace, and then just this week passed the bar. So it's unbelievable. I mean, so as I said, I became aware of his story online. We talked briefly on the phone, and like I said, I thought, holy cow, I was so impressed. And I did a podcast, which is on our website at Restorative Justice International. And because of the work that we started to do, we invited Jeff to be on our Global Advisory Council at RJI, which he agreed to. And he is now a national and international advocate for those who are wrongfully convicted. And in 2008, RJI worked with Jeff and other advocates in supporting New York legislation, creating a prosecutorial conduct commission. And you've heard about that. That bill was signed last year by Governor Cuomo. And we praise him for his work, and also Bill Bastick, who's here tonight. But Jeff is a friend and a colleague, and as we work together to reform the criminal justice system, it includes ending wrongful convictions. You will never find a man more passionate and hardworking as an advocate for the innocent men and women in prison than Jeffrey Deskovic. I give you Jeff.
Good evening.
Good evening.
Not really sure that I'm, you can put the first slide up. I'm not really sure that I'm like here tonight, here, you know, in Davis, California, because it's, my life has had a journey that I could have never anticipated. From being arrested and ultimately wrongfully convicted, to being exonerated, to becoming an advocate, to graduating law school, to doing advocacy work, to speaking in other countries and speaking across this country. I could never have anticipated any of this. So it's kind of surreal, and that's what I mean by that. So I was wrongfully convicted in 1990. I had been arrested when I was 16. I got bailed out. I turned 17 by the time the trial rolled around. And I was wrongfully convicted based upon a coerced false confession, prosecutorial misconduct, fraud by the medical examiner, terrible public defender. Wow. Let me unpack that a little bit for you. Before I was a teenager, I wanted my career, what I wanted to have when I became an adult, was I wanted to be a cop. So for about 6 weeks, the police played this cat and mouse game with me, in which half the time they would talk to me as if I was a suspect, and the other half the time they would pretend like they needed my help to solve the crime.
Okay.
They would say things like, the kids won't talk freely around us, but they will around you. Let us know if you hear anything. Stop in from time to time. They would ask me opinion questions and congratulate me that my opinion was correct. I came from a single-parent household. My father was never involved in my life. I never actually met him until 6 months after I had been exonerated. And that directly intersected with the good cop, bad cop tactic, otherwise known as Mutt and Jeff, in which one officer takes on a more aggressive role, whereas his partner pretends to be opposed to what's going on, but somehow powerless to interfere.
So you've been talking, yeah.
So eventually they got me to agree to take this polygraph test, otherwise called a lie detector test. Some new information had come into the police file, so they said, and they wanted to share that with me, and that would allow me to be even more effective in assisting them. So the next day, rather than report to the high school, I instead went to the police station where I had heard through the rumor mill that the other people had been polygraphed at. Since it was a school day, that meant neither my mother nor my grandmother with whom I lived thought anything was wrong, so they didn't call around looking for me. They drove me across county lines. I'm from Peekskill in Westchester County, and the Peekskill police, they drove me from Peekskill 40 minutes away by car to the town of Brewster, which is in Putnam County, which meant that I didn't know where I was. I wasn't able to leave anymore. I was totally dependent upon the police. There were 3 officers there who had came with me from Peekskill, but then there was also the Putnam County Sheriff's investigator, the polygraphist. But he was dressed as a civilian. He never read me my rights. I never learned until much later after I'd been arrested that he actually was a police officer. He gave me a 4-page brochure which detailed how the polygraph worked, and it had a lot of big words in it which I didn't comprehend, but then again, so I thought I was there to help the police. What did it matter? Let's just get on with it. So from there they put me into a small room and they gave me countless cups of coffee, which seems fairly clear that the purpose of that was to get me nervous. It was to wire me up.
Right.
The premise of the polygraph is that when a person tells a lie that you'll become nervous and your nervousness will result in an increased pulse rate, and it's actually the pulse rate which is measured by the machine. But other factors which would lead to an increased pulse rate could also involve caffeine and certainly fear. So the coffee was part of the setup. So from there he attaches me to this polygraph machine, and now I was immobile. I could stand up, but that said, I couldn't take a step. The machine was very heavy, and there wasn't very much slack in the wires. So then he launched into his third-degree tactics. So he invaded my personal space. He raised his voice at me. He kept asking me the same questions over and over again. I was 16 years old, and he was a mountain of a man, a fully formed adult, and I wasn't used to talking to adult males, and so the manner in which he was conducting himself made it extremely frightening for me. Each hour that passed, my fear increased in proportion to the time. He kept that up for 6.5 to 7 hours. Eventually he said, "What do you mean you didn't do it? You just told us through the test result that you did. And we just want you to verbally confirm it." So when he said that to me, that really shot my fear through the roof. At that point, the officer who had been pretending to be my friend, he came in the room and told me that the other officers were going to harm me, but that he had been holding them off previously but couldn't do so any longer. You have to help yourself here, you understand. Well, considering that I maintained my innocence for the previous 6.5 to 7 hours, it was clear what he meant by that. They wanted me to confess. When he added that if I did as they wanted, they'd stop what they're doing, that I was not going to be arrested, being young, naive, frightened, 16 years old, not thinking about the long term. I was only concerned with my safety in the moment. I was in fear of my life. The fact that I didn't know where I was and that nobody else knew where I was either loomed very large in my mind. I was overwhelmed emotionally and psychologically. And there was the push-pull dynamic in play, because on one hand the possibility of harm had been thrown in the air, and on the other hand the false promise that I wasn't going to be arrested. By the time everything was all said and done, I had collapsed on the floor into a fetal position. I was crying uncontrollably. Needless to say, I was in fact arrested. That interrogation, by the way, was not videotaped. There was no audio tape. There was no signed confession. There was simply the cop's word for it. And as a result of that, they were able to leave the threat and false promise out of their testimony. Before I went to trial, the results of a DNA test came in from the FBI lab showing that semen found in the victim didn't match me. The DNA excluded me. But instead of acknowledging they made a mistake, instead they continued to prosecute full speed ahead. This is where the prosecutorial misconduct comes in. When there's an autopsy done, there's audio and written notes which are taken contemporaneously as findings are made by the medical examiner. So it was only after this DNA didn't match me that suddenly this medical examiner claimed that he remembered that he forgot to document medical evidence. This is 6 months later, hundreds of autopsies later, he remembers that he forgot to document medical findings which he claimed proved that this victim, a 15-year-old immigrant from Colombia who had been in the country for about a year and a half, leading a pretty sheltered life. As I understand it, she never went anywhere unless she was accompanied by her older sister or her parents. He claimed this medical evidence proved that she was sleeping around with just about everybody in the city. That's what allowed the prosecutor to argue that it didn't matter that the DNA didn't come from me. That didn't mean I was innocent. There was yet another person that she slept with prior to my raping and murdering her. Taking it a step further, he actually named another youth by name that he claimed had slept with the victim.
That's mine.
But he never bothered to first set a proper evidentiary foundation. He never had that other individual DNA tested. He never even called him as a witness. He just made the unsupported argument from the jury. My public defender essentially didn't defend me. He never interviewed or called as a witness my alibi. I was actually playing wiffle ball when the crime happened. When it was time to cross-examine the medical examiner, my lawyer stood up in open court and with a big smile on his face, like him and the ME were great friends from back in the day, said to him, "You're going to be pleased to know that I don't have a single question for you."
No, he did not say that.
My lawyer never explained to the jury the significance of the DNA not matching me. He never used that to argue that proved that this confession obtained under highly questionable circumstances was coerced and false.
Oh, my God.
I wanted to testify at the pre-trial hearing about the threat and the false promise because I was the only person other than the cops that could have added those facts to the record. But he wouldn't allow me to testify at the pre-trial hearing. He said he hadn't decided if I was going to testify at the trial or not, and he didn't want to have me testify previously than that potential appearance at trial, which didn't really make any sense because, first of all, if the judge had believed me, the statements would have been ruled involuntary and they would not have been admissible, and lacking any other evidence, there would not have been a trial. But secondly, if it really did go badly, I didn't have to take the stand at the trial, and if I didn't, there would be no way the prior testimony could be used.
Right.
But then when I got to the trial, he wouldn't allow me to testify there either.
Why?
He informed me that it wasn't his job to prove that I was innocent. It was up to the prosecution to prove that I was guilty, and he didn't think that it happened. That might be a legal principle, but that's a very naive way to practice law. In reality, if your client is charged with a crime that they didn't commit, you have to try to prove that they didn't do it, or your client runs a risk of being wrongfully convicted. Particularly in a confession case where there's an 80% conviction rate. I mean, the most people don't believe that an innocent person would confess. So if you're confronting a case against a client for a client in which there's a confession, you have to answer that confession. You have to explain why it was given. When I hadn't decided if I was going to go with a jury trial or a bench trial, one day my lawyer came to me and told me that the judge told him off the record to pick a jury because he didn't want to be responsible for finding me not guilty. That was improper for the judge to limit my decision that way because we were thinking about going with a bench trial. But by him making that comment, it made it impossible. My lawyer was supposed to put that on the record and ask the judge to recuse himself, because a statement like that shows bias, and it suggests that perhaps he's feeling public pressure, because just about every time I made a court appearance, it was a major media moment with virtually all of the coverage from a guilt presumptive-oriented perspective. Added all up, I was wrongfully convicted. When this happened, I was not the adult that you're looking at here tonight. And so, to bring that to life, I'm going to go with the first slide now. This is a picture of my mugshot. The next slide will show me in the courtroom after it was announced that the jury had reached a verdict, but prior to it being read. The next slide will show what I looked like at the sentencing hearing. The next slide will show what I looked like shortly after arriving in Elmira Correctional Facility, which was a men's maximum security prison, because that's where they send you if you're charged as an adult. This is in New York. I want to share with you how it was that I came to be exonerated. I went to the appellate division. My issues were my innocence, wrapped around the arguments that there was legally insufficient evidence, that the prosecution hadn't proven guilt beyond a reasonable doubt, and that the verdict was against the weight of the evidence. My lawyer argued that my Fifth Amendment rights had been violated, even without the threat and false promise on the record. And they raised six issues of law. The appellate division wrote that I was not, in fact, in custody, that I was free to come and go as I wanted. That influenced their decision in deciding that the statements were voluntary. They rejected all of my innocence arguments by writing that there was overwhelming evidence of guilt, which is kind of a head-scratcher even to this day, considering that the DNA didn't match me. And then they got rid of my other issues of law in one sentence by writing that they had looked at my issues and found them either to be without merit or else not preserved for review. They ruled against me 5-0. That was the most that the court ever wrote. My re-argument motion was denied in one word. New York State's highest court declined to give me permission to appeal to them. I lost in federal court because my attorney had been given the wrong information pertaining to the filing procedure, and so my petition arrived 4 days too late, which the then district attorney took the opportunity to successfully get the court to simply rule that I was late without ever looking at my issues. I challenged that ruling in front of 3 more courts, including the U.S. Supreme Court, but I was turned down each time. I wrote letters for 4 years, rarely getting answers. The goal, of course, was to try to find pro bono representation because I couldn't afford to hire a lawyer. The goal was to get the representation, but also get an investigator, because once your appeals are exhausted, the only way back into court is either if the court makes a retroactive decision in the law and applies it backwards, which almost never happens, or if you can find some previously unknown evidence of innocence. I wasn't going to find any unknown evidence of innocence myself personally while I was locked up in prison, so hence writing letters, trying to find representation. I did that for 4 years. I rarely got answers other than the occasional no. I went to the parole board, where I stood on my innocence rather than express remorse and take responsibility. And in large part based upon that, I was denied parole. I wound up, that was at the end of my 15-year sentence minimum term. I wound up doing an additional year before I was exonerated through further DNA testing. The DNA data bank had been created, and getting the Innocence Project representation was the first of 3 key factors. Another one was that the district attorney who had took office, Janine Pirro, she left office. She had fought all of my appeals and blocked me from getting further testing several times. So she left office, and her successor was not as dug in as to my case, and she allowed me to get further testing. As I understand it, she didn't like her predecessor, and her predecessor was in the middle of running for Attorney General, so that's part of the backstory of why she allowed the testing. hoping that I would be exonerated to ruin the Attorney General run. I'll take it how I can get it. And the third thing was we got lucky, and this is where wrongful conviction as a public safety issue really crystallizes. And this is a big part of the intersection why crime victims have a stake in wrongful conviction, is because the actual criminal left free while I was doing time for his crime. He killed the second victim 3.5 years later, who had a couple of children and who was a school teacher. He later admitted that he was the person who committed the crime, not just to law enforcement, but also to a reporter on video camera. So on September 20th, 2006, my conviction was overturned and I was released, and I reported back to court on November 2nd, 2006, at which point all the charges against me were dismissed on actual innocence grounds. I've found some purpose in what happened to me. I consider that my role in the world is to fight wrongful conviction, and that's how I make sense of things in a kaleidoscopic type of way. You know, I find it healing and I find it cathartic. I did open a nonprofit organization which was referenced before in the intro, the Jeffrey Deskovic Foundation for Justice, and we have been able to free 7 other wrongfully convicted people in 6 years. I want to look at a couple of more slides I'm going to share with you. So Evan, please, the next slide. There's another picture of me while I was in prison. The next slide. This is when I was released. Go to the next one. This is a picture of me and my mother. That was our first hug in the free world in 16 years. The next slide will illustrate, this is when I started the foundation. Wrongful conviction can and does happen to anyone. To my right in the red tie is Fernando Bermudez, who's listed in the National Registry of Exoneration. He was exonerated after 18 years in Manhattan. And then to my left is Jabbar Collins, who did 16 years before he was exonerated in Brooklyn. And to his left, you might recognize Raymond Santana of Central Park 5 fame, who was exonerated along with his other 4 co-defendants. Next slide. This is the first person we exonerated. This is William Lopez, who did 23.5 years in a murder case which he didn't commit. We came into his case in the last year. We did some investigative work in collaboration with his pre-existing legal team, and he was released. He was exonerated. His entire adult life was stolen from him because he passed away after being home for 1.5 years. The next slide, to my left, that's in the red tie, that's William Hawley, who did 8 years and 4 months in an arson case that actually was an electrical fire. In that case, we did the entire case by ourselves in-house, and the end result of it all was that the Butler County District Attorney's Office stipulated that our client was innocent. They stipulated to everything that we had found, so he was exonerated. So changing gears, I want to talk about the theme of tonight of progressive prosecutors. The results that can be obtained when a prosecutor is elected who's running on a progressive plank can be breathtaking. In Dallas, the first district attorney who had the conviction review unit, Craig Watkins, more than 40 people were exonerated through his conviction review unit. In Brooklyn, Ken Thompson exonerated 23 people in 2.5 years. And as was mentioned earlier, Larry Krasner in Philadelphia has exonerated 10 people in 20 months. So there's a number of benefits, to having progressive prosecutors. In the first place, just the fact of somebody running as a progressive prosecutor can significantly further the issue. Not so much that you're going to push your opponent into suddenly being progressive. They're going to imitate some of the rhetoric, but they're not going to implement. But it's more on the level that you're going to raise public consciousness about the problem of about the problems of the justice system. It can raise the issue of wrongful conviction. Ken Thompson ran on a wrongful conviction plank. You can inject other issues into the district attorney's race, such as prosecuting police who engage in police brutality, such as prosecuting police who engage in deadly, unjustifiable, deadly police force, such as diversion programs, drug usage as a public health problem, and diverting nonviolent offenders from incarceration to rehabs and other programs that are more oriented to rebuilding their life and returning, to being restored and trying to lead a crime-free life. But then once you get in office, if they get in office, so you can have a real conviction review unit whose employee names are known, that has a budget, that don't do things on the side as needed, but instead their work day in and day out is to correct wrongful convictions. You could implement a step-back approach in which, as an individual prosecutor, you pretend like you're a jury, that you're a judge, and you scrutinize the case that the police brought to you, and you look for troubled signs that a confession may be false, or that an informant might be lying, or that an identification is false. You look for those patterns that have appeared in cases that have previously ended in DNA exoneration. You scrutinize the case rather than blindly prosecuting everything. You can implement discovery in which both sides have access to the same information, so a trial really is the search for the truth rather than trial by ambush. You can set the culture in the office, in which being a minister of justice, which means dismissing against innocent people, which means convicting the guilty with lawfully obtained evidence without violating rights, without overcharging, without seeking over sentencing. You can establish that if it's discovered that there's a clear-cut intentional case of misconduct, that employee is going to be fired immediately. You could end overcharging and the other issues which I mentioned. You can implement, now that you ran on those. You can divert people from incarceration. You can encourage restorative justice. You could get involved in innovative programs like prisoner reentry. That's crime prevention. That has something to do with the office, to be sure. You could send letters to the parole board. In the case of people who've been model prisoners whose rehabilitation is clear, they can make an appearance at the parole board with a letter on the DA letterhead recommending that they be released after noting what their disciplinary record and educational record is. But then those are things that are directly within your control as a district attorney. But then your voice counts a lot on legislative issues that are not within your control, but that are instead matters reserved to the legislature. So you can speak up about criminal justice reform issues. You can speak about mass incarceration, right, when bills are considered for that. You can speak about aging people in prison. You can raise your voice up when it comes to parole reform. You can speak up about college education for prisoners, which is a major crime-fighting tool, by the way, in the sense that the recidivism rate's extremely low for those who have received a college education in prison rather than those that have not. You can speak up about wrongful conviction prevention measures, such as videotaping interrogations, such as better identification practices. You can speak up that there should be an even budget between the public defender's office and the district attorney's office. You can speak up with some of the institutional disadvantages that hamper even the most determined public defenders, such as having way too large a caseload, such as the inequities in which the district attorney has access to a lot of investigators and experts, and the defense is relegated to asking the judge to allocate funding, which a lot of times is denied because the judges want to keep the costs of the trial down on the counties. You can speak up about those things. You could speak up about a broken compensation system, such as, for example, since we're here in California, a system that in order for that you have to have either the prosecutor stipulate that the defendant who is exonerated is in fact innocent, or a judge to say that. Even if the conviction wasn't reversed on innocence grounds, you need the judge to say that. Otherwise, this is how this crazy system is out. And even then, it'll be up to the governor if he's going to sign the bill or he's not. And even if you somehow run that whole gauntlet successful, do you know what you're going to get? You will get $140 a day. That breaks out to about $50,000 a year. That's an insult of an amount of money for a year of wrongful incarceration. So as a district attorney, you could speak up about that kind of practice. Lots of benefits for progressive prosecutors to the community. But on the other hand, the opposite is true. Prosecutorial misconduct is a major cause of wrongful conviction. To relate it back to California, so there's been 707 court-identified instances of prosecutorial misconduct. 46 of the prosecutors in those cases were repeat offenders on the misconduct, and only 6 people out here in California, all those numbers are California numbers, only 6 people actually were disciplined. One of the big examples in prosecutorial misconduct is a case that was spoken about before, but I want to just quickly go through it, just to highlight it, because in a lot of ways it's a reason why we need to address and do something about prosecutorial misconduct. I'm talking about the Ann and John Alexander case. And let me have the next slide, by the way. Okay, here we go. Okay. This photo is an illustration, by the way, that fighting wrongful conviction is not something that you're fighting against law enforcement. This is public safety, and it's about justice and accuracy. And this photo here shows that there is buy-in from some law enforcement. Next photo is another class. They brought me in to do the ethics and best practices portion of the training for the cadets as they neared graduation. The next photo. Next photo. And one more. So, I mentioned the Ann and John Alexander case. So he was charged with, 3 counts of rape. He was a high-profile fashion designer. He was charged with 3 counts in Texas, in Dallas. All of those were dismissed when he requested to go to trial. He was charged with a count in Houston that was also dismissed. Then in New York, he was charged with 49 counts. 39 of them were dismissed before trial. 39 were dismissed before trial. And that left another 10. So the court made this agreement with him. And this is kind of like a really big illustration of prosecutorial misconduct. So the deal was, if he agreed to plead guilty to one charge, they would dismiss the other 9 and give him the crucial exculpatory information which he needed in order to file his habeas petition here in California. Does anyone think there's something wrong with having to plead guilty in order to get exculpatory material that you need to file a habeas attorney, or am I the only one? But thinking on his feet, he decided to plead guilty to a count that had already been dismissed, with the idea if he ever managed to come up under everything, he could come back and knock that one out. And so he pled guilty to 1 count of forced oral copulation on a female, an adult. So if you can think that's kind of nuts. In California, he was charged with 59 counts, and so he was convicted of 35 of those were dismissed. He was convicted of 15, and the jury deadlocked on some of them, and some of them he was acquitted. So in terms of the validity of this case and whether or not he was wrongfully convicted, a couple things kind of jump out at me. So first of all, witnesses who were not believed in one jurisdiction were believed out here in California. So that's the first sign that something's not quite correct. But another thing is that, photographs taken from MySpace accounts, which is attorneys and legal team, of which one of them is here tonight, of these victims, kissing him. Who does that? Who kisses your rapist like a year after this, rape happens? It's crazy. But then there was, the prosecutorial misconduct involved in that. It was claimed that the victims had no financial motivation except that they in fact were planning lawsuits, and it was claimed falsely that they didn't know each other and that the sheer number of victims was a reason for believing the charges, because who's going to come up with that type of big conspiracy? But in fact they did know each other, and they were all, one person was recruiting the other. But they were told not to bring race and religion into the trial, except that the prosecution did. They did not share exculpatory material, including a criminal record from some of the witnesses, including one person who had been charged with previously falsely accusing somebody in a sex offense case. So that's the case that we're talking about. So in a lot of ways, Annan's case is an example of prosecutorial misconduct. We can share the next slide here. And one more slide. So currently there is an effort to exonerate him in court, but at the same time, because the wheels of justice often turn slow and the results of efforts to exonerate are anything but certain, a second front is opened in which Annan is seeking commutation. So I do call on Governor Newsom to grant the time commutation so he could be released from prison. He's not even planning to stay in the state. He'd like to go back to India so where he could be with his family. So he's done quite a bit of time, and I don't see why that couldn't be done. In terms of remedies for prosecutorial misconduct, so I'm an advisory board member of the coalition group It Can Happen to You, and we went from idea to signed legislation in 8 years. A landmark bill was passed in New York, creating the country's first commission on prosecutorial conduct. The current grievance system, oversight system, is totally ineffective. I gave you the stats earlier. Lawyers often don't file complaints because they know that nothing is going to happen, and because they know they're going to suffer retaliation, and their future clients will suffer retaliation. Plea bargains that would otherwise be extended would not be. The commission, in contrast to that, the commission complaints could be anonymous, or the commission could proactively look at cases on its own. It would have subpoena power. They would have the expertise in dealing with prosecutorial misconduct. The present grievance system, that's more oriented for defense lawyers and civil lawyers who do things like commingling funds. It's not there really for prosecutorial misconduct. It would dovetail with the legislation that was passed here in California, making it an E felony when exculpatory material was withheld. But so far, who's being prosecuted when that happens? And it's largely because the offenders aren't identified. So the commission, upon reviewing complaints and substantiating it, it would then be public. And so those offenders, those criminals who parade as court officers and upholders of the law as prosecutors, so that they could then be prosecuted. So that's the purpose of the commission. And we've begun working here in California to build a statewide coalition to bring our blueprint of success from New York here in California. So, we're going to be, working with many of the people here in the room, and we're going to build a statewide coalition. We're going to be in California on a semi-regular basis, and certainly we need everybody here in the room and throughout the state, to work with us in coalition. Maybe the last thing I'll point out is that, you know, and this is another reason why the commission is important, because it's not just reviewing things after the fact, but it's also deterrence, prevention. When somebody is falsely accused, even if the charges are dismissed, even if they're acquitted, their world has been turned upside down. Were you really innocent? Did you somehow get off? What about the mental strain? What about the reputation? What about families not knowing if their loved one is going to be going away for crimes they didn't commit? Jobs are lost, businesses can be destroyed, financial problems can set in. I want to mention a couple people with us, and I'm going to end on this, that, you know, had charges, had false charge, had a false murder charge and assault charge, you know, dismissed against them recently. And they drove 14 hours from the state of Washington to come to Sacramento to meet us in person, to come to this event. I would like to ask to stand for a second. James Fair and his wife Angela Fair, they were both falsely accused and charged with dismissed recently. So with all of that, I want to thank everybody. I know it's been a long night. Thank you so much for your attention, and hey, thank you for celebrating my birthday with me.